Your Honor, I asked leave the court for 5 minutes to consult with my expert witness, because he would be next on the list, and if he's not going to testify, he's not being allowed to testify. Where is he?
Well, I'm going to review his report. I'm not saying he can't testify at the ultimate hearing in this, which we'll have at some point down the road, but at today's hearing, like I already said, I'm going to I'll read through his report, take a look at it, read through it again, actually, and see how it kind of meshes up with what I've heard.
Can I confer with him?
Of course you can. You want us to stand in recess? Okay. Hold on, before you do that, because people may, do you have any witnesses, first of all?
No witnesses.
Okay.
Your Honor, the county was just going to go forward on an offer of proof that we do have the county administrator here as well. So the county offer would like 30 seconds, maybe 60 seconds.
Okay. All right, we'll stand in recess for 5 minutes, and we'll resume whenever you're prepared. Thank you all.
All right.
Actually, hold on. I did want to say one thing. We're off the record. Because I have a funny feeling a bunch of people are probably going to leave. And I did want to address the crowd, and we're off the record. And I know I told the bailiffs that everybody had to have a mask on in this room, and most of you complied, some of you didn't. And it just wasn't worth it to me to take it to task for having fellow citizens defy my wishes. But let me tell you why I did it. And it's something that most people don't think about. The court's also an employer. And we got a few people out on right now because of COVID, and they're really sick. The clerk of court's out. Judge Torrey was out last week. And when there's only 4 of us here, 4 judges, and when one of us goes out for 10 days, it really affects the administration of justice. And it really affects all the staff. And I did it because I want to protect them and keep them safe. What people do in their own lives is okay, but that's why I was insistent on it. To those of you that complied, I thank you. To those of you that didn't, I just didn't want to make it a show of force and turn this into something it didn't need to be. Thank you.
Thank you.
Back in session.
Thank you. Please be seated. Okay, we're back on the record. It's 244 and Daniel Richard versus Danagunan and others. Docket number 218-2022 CV 676. All right, Mr. Richard, have you had a chance to discuss things with your experts?
Yes, Your Honor. What I want to point out to you that I didn't emphasize earlier is that the state alluded to explosions. I want to get away from explosions, obviously, and get to the point of what the real safety issue is here, which is anyone that possesses a prosthetic, pacemaker, or other devices is possibly at risk here. So this is a public health, public safety issue to allow these devices to continue to be used until we resolve these underlying issues. So with having said that, I'm going to object to denying just to put it on the record that I object to not allowing my expert witness to testify, because safety is always paramount. And that's what this is all about. I'm simply asking this court, and the reason I asked for this hearing was for a simple thing. There is no harm to come to hand counting this ballot to make sure that we preserve the integrity of this vote. Right now,
When you say this vote, you mean the one next Tuesday?
the one next Tuesday, because as the state alluded to, I didn't do this at the last minute. I've been trying since at least February.
Well, let's talk about that, because that's one of the things that's kind of bugging me. is that I'm all for doing things for public safety. I just tried to get everybody to wear masks. But the other issue is, if there's an exigency, but the delay in your filing the lawsuit kind of causes that. I mean, I think if we had argued about this in June, which I don't see a reason why we couldn't have.
I personally didn't possess any knowledge of the safety factors.
Okay, explain that to me. Explain why you filed the lawsuit when you did in so close proximity to the election.
Absolutely.
Because some people do that for tactical advantage.
Absolutely, Your Honor. My journey with this challenge of changes to our voting laws starts with a first remonstrance filed 2 years ago with the legislature changing by statute that which requires an amendment. So that's the basis of the rest of the suit. So counts 4, 5, and 6 in the suit all deal with older issues that I've been trying to resolve through the administrative remedy, through working with my legislative body, including filing a petition with the state Supreme Court, which was argued over the right to redress a grievance. The underlying issue of the remonstrance there was items 4, 5, and 6 in this case. And so, having said that, after unresolving that issue through the redress process through the legislature and exhausting that remedy through the court, that was the court of proper jurisdiction, right? The state constitution provides that only the legislature is authorized to suspend the law or to change provisions within, changes to their legislative actions that are repugnant contrary to the Constitution. And so, having exhausted all that, I recently, in the last month, finally got my motion to reconsider from the ruling from the state Supreme Court. I then moved, so that's 2 years old. So that begins back 2 years ago. In February of this year, when I came to the awareness of machines and the problems and the possible legality issues, that's where I started my investigation on adding the machines to my concerns about how our voting is conducted. So having done that, I then came to the awareness of the expert witness. I didn't know him until just a few months ago. Someone introduced me to him, and then I found out what his background was. A few weeks ago, I asked him to look at this from his perspective and his background. So that's why this is new information, and it was not done to the last minute. I would point to the state, that the state did nothing since February other than the Attorney General's office issued, I'm sorry, it wasn't the AG's office, it was the Secretary of State's office. When we gave the remonstrance to the legislature, to the Secretary of State, to all the powers, all the players involved, and then I served my town. And after the town got a copy, not only did they get a copy of the remonstrance filed with the legislature, but they also got a copy of the notice of trespass, because I believe they were trespassing on my constitutional rights. Part 2, Article 32, says that 3 elected human beings are responsible for sorting and counting the vote. The moderator is elected to sort and count the vote from the selectman or the town or city clerk. That has never changed since 1783. There is no amendment. And under Worcester versus Plymouth, the state constitution must be interpreted the way it was written on October 31st, 1783. There was no technology, there was no electricity. Counting by hand, and what we refer to today as voter integrity. What do we do when we challenge the outcome of the election? We hand count. Why is hand counting a de facto? Why are we ignoring the hand count and using a device that isn't even law? Statute 656:40 isn't law. Let me explain. 650-640 is the origins of the voting machine. Okay? It came to us in 1979 on a trial basis. Your Honor, 43 years cannot be a trial basis. That's what they're hanging their hat on. That's where their legal justification for using these devices begins with. It begins with this temporary use authorization. And here's the kicker. We're not a home rule state. The legislature can't delegate to the town under non-delegation doctrine and give the town the ability to make law. It can't make law. The legislature makes law. So what does the statute say? It says that it applies to the Ballot Law Commission. Who's the Ballot Law Commission? An unelected body. An unelected body who then, you ask this unelected body as to whether you're going to ignore the provisions of the Constitution. So that's kind of the backstory of what's going on with the the various changes to how we got here today. So yeah, this is not something new. I didn't wait till the last minute. The only reason this emergency hearing was brought forward was because of my serious concerns about safety. Thank you.
Croc TV.